Hello, welcome to the program. First tonight to what may be one of the biggest miscarriages of justice this state has ever seen. When Henry Keogh was convicted of the murder of his fiancée, Anna Jane Chaney, it was dependent on the forensic evidence of the state's former chief pathologist, Dr. Colin Manock, a man whose professional performance had already been seriously questioned, with concerns that he'd made critical errors in numerous cases of suspicious deaths. Well, now a national team of 28 eminent legal and medical experts has come together, volunteering both their time and their expertise because they're so concerned about what they see as the blatant inaccuracies and inconsistencies in the Keogh case. As Graham Archer reports in this special investigation, some of the sharpest legal minds in the country are adamant that this case urgently needs reviewing and urgently demands a response by the state government.
For a person involved in the prosecution to say there was other weighty evidence against an accused person in any event is just no answer. It shows a complete misunderstanding of the judicial process.
My view, and I said it at the trial, is that I don't think this case would have got to court in Victoria.
Though it's had scant mention by any other media, this may open the state's biggest legal scandal.
It seems to me that there should be no hesitation about ordering an investigation.
After years of resistance, the medical board is obliged to do its duty by conducting an inquiry into the work of former chief pathologist Dr. Colin Manock, starting with his actions in the prosecution of Henry Keogh.
Faulty forensic evidence simply means, as it did in Lindy Chamberlain's case, that an innocent person gets sent to jail.
According to their act, this should have occurred years ago after his errors in the Emily Perry case in the 80s and the baby death cases of the mid-90s. Just as, in Britain, medical authorities have responded after famous pathologist Sir Roy Meadow was exposed as giving faulty evidence in scores of baby death cases.
The UK Attorney General has ordered a review of almost 300 cases where women have been sent to jail in respect of murdering their children, where the evidence now suggests that the so-called eminent expert medical evidence given could well have been fundamentally flawed.
But this is South Australia. Things are done differently here, if they're done at all.
In this country, you can get law and order and increased police powers and increased powers for prosecutions at the drop of a hat. Try to do something about miscarriages of justice, you might as well just go and sing in the wind.
With the apparent indifference of the local criminal law community and resistance from attorneys general past and present, now a national team of eminent lawyers and medical experts have volunteered to add their weight to the need for a review.
I have been shown a number of affidavits from very eminent forensic pathologists who question the conclusions reached by Dr. Manock. They are so eminent and so numerous that it is hard to understand, unless there is other evidence that I don't know about which would have a countervailing effect. It is hard to understand why an Attorney General would not, without hesitation, direct an appropriate inquiry into the matter.
John Nader QC is a former New South Wales Supreme Court judge. Having sat on the final appeal which freed Lindy Chamberlain, he understands adherence to the proper procedures is vital to any justice system.
It's quite clear that if those rules are not observed, there will almost inevitably be miscarriages of justice.
Welcome to SA. He's joined by Perth's Tom Percy QC, Tim Game QC from Sydney, Stephen Howell QC from Melbourne, and Terry O'Gorman from Brisbane.
In Australia, and I include all states and territories, including South Australia, we are so smug and complacent about how fantastic our court system is that we need an urgent wake-up call.
But none of this was followed up.
As most would know, Today Tonight, in conjunction with others, has spent a couple of years investigating this state's often self-serving justice system. The Keogh case being just one example. What's emerged there is a litany of failures, from police crime scene procedures to the handling of the body, its premature cremation, the destruction of evidence, suspicions raised to police and attorneys general which were never pursued, all starting with the strange events of that night, such as evidence of Anna Jane's missing car, and on it goes.
The primary focus is always a search for the truth.
Robin Napper is a former Chief Inspector of New Scotland Yard, now with the Department of Forensic Science at the University of WA.
Unless the investigation is thorough, then the court proceedings aren't going to be complete, because they're only getting a part of the story.
And of course, vital to many investigations was Dr. Colin Manock, who conducted 10,000 autopsies based, in many cases, on very questionable science.
Often jurors are bamboozled, but particularly when they have an expert before them who is told by the prosecutor that this expert has been giving evidence for 20 or 30 years, most jurors say, well, this bloke must be unassailable. Well, that's the problem in the UK.
Has the possibility of natural causes been properly excluded in what you've seen?
No, it has not. And the answer to that question is no.
Professor Stephen Cordner is the Director of Forensic Pathology in Victoria. He says almost no other expert in the country would propose a murder scenario as Dr. Manock did.
I had difficulty thinking that many, or possibly even any, pathologists in Australia would think or say the same thing.
It's a disturbing example of an investigation being prejudiced from the start, much of which came via this woman, now retired police officer Pat Walkley, then attached to the coroner's office. She recorded the suspicions of the Cheney family, treating opinion as fact. On the day of the autopsy, she added the following to the coronial running sheet.
The whole family hated Henry Keogh.
She even came up with her own recipe of murder and committed it to the official record.
I wonder if he hadn't come home and found her asleep in the bath and pushed her head down into the water, hence the mark on her forehead.
In fact, the mark referred to is almost certainly a blemish and has never been referred to since. But she then goes on to say,
"It's not sounding too pleasant. He is a very odd fellow and strongly built."
Hardly the product of an open mind, as she seems to have steered the investigation in just one direction, and later boasted to Four Corners,
"Keogh is an evil, evil man. If it wasn't for me, he wouldn't have been locked up."
So it was Walkley, fuelled by the comments of the Cheney family, who speculated on the insurance policies as the motive, even though they clearly knew of their existence. Walkley circulated the theory to anyone who'd listen, including Dr. Manock, exposing as nonsense what the DPP Paul Rofe later tried to suggest had in fact been done.
I mean, accidental death was obviously something we had to disprove.
Accidental death was never ever tested at all, a fact Dr. Manock makes clear as he ignored the most basic rule of forensic investigation.
I was at no time looking or thinking that the death was accidental, because I could find no explanation as to why she would drown.
The mind needs to be open right from the start.
And would you say that's a basic requirement of a pathologist, to keep all options open?
Yes, it is, particularly initially.
Well, next, the case apparently prejudiced from the start. The expert's not even prepared to consider that it may not have been murder after all, how the evidence was made to fit.
I don't think that other possible causes have been reasonably excluded. There is little evidence to support the grip theory.
With a concerted presumption that it couldn't have been anything else but murder, that was the only light that evidence was examined in. Even though the independent experts say it simply doesn't make sense, and in fact there was much more evidence suggesting Anna Jane actually died of accidental or natural causes. As Graham Archer continues in this special report, all other considerations were apparently rejected in the effort to convict a man of murder.
I find it difficult to think that there'd be many, if any, other pathologists in Australia who'd be comfortable with proposing a murder scenario in court and saying that's what I really think this case is. And for me, I need to be able to, you know, get to sleep at 11 o'clock at night and have 8 hours sleep, so that's not the sort of thing I could have done in this case.
With nothing but murder in his sights, it became a matter of selecting evidence which fitted. Hence, the so-called bruises on Anna Jane's left calf were used to support the improbable theory that Keogh gripped it and raised Anna's legs above her head to drown her. It's why on proper inspection it makes little sense, but worse, the critical bruise may have never existed.
And the material that from this specimen that's looked at under the microscope shows minimal, if any, bruising at all.
Dr Byron Collins is a Victorian independent pathologist working in private practice, who also has serious misgivings about a presumption of murder.
If there is an inconsistency, then yes, I think that should be investigated with as much rigour as possible.
Equally appalling is that since the possibility was first raised by expert pathologist Professor Tony Thomas, he's been the subject of a personal attack by the Attorney-General in Parliament in an effort to discredit him. And, aided by Paul Rofe and others, there seems to be an effort to shift the focus away from the significance of those highly dubious bruises.
The forensic pathology wasn't going to provide the answer. I mean, it was necessary and important background.
It is not enough, by the way, to say, oh look, there is other evidence in the case that was pointed very strongly towards the guilt of Keogh. Because a trial that's tainted by any evidence that may have operated on a jury's mind to shift them to the point of being satisfied of an accused person's guilt beyond reasonable doubt taints the whole trial.
The concerns raised by Professor Thomas are supported by many other pathologists and medical experts who say there's much more evidence to support death by natural causes.
But I don't think that other possible causes have been reasonably excluded.
What do you think of Dr Manock's claim that the bruises on top of the head ruled out any possibility of an accidental death?
A slip in the bath from a woman who has a blood alcohol of 0.08, perhaps standing up in the bath suddenly, getting a faint. So to me it's to use that as some sort of support for a murder scenario seems, I can't understand why it tells between one thing and the other.
But what's now emerging is something much more alarming.
Is there any objective proof that that you know of, that a section was taken from the inside of the left leg?
No, there's none that I know of, or that I have been shown.
As stated, the most doubtful bruise is the one on the inside left calf, which Dr Manock claimed proved Keogh had gripped the leg.
I think there is little evidence to support the grip theory as described by the pathologist in this case.
And it's here that Dr Manock's offsider and successor Dr Ross James now also comes under scrutiny. His advice has become crucial to the Rand government's attempts to close off any further inquiry. He's been liberally quoted by the Attorney-General while relying on sympathy for the Cheney family to justify his political agenda.
He, Dr James, concluded, while the opposing thumb bruise will corroborate a grip mark, the opposite is not true.
And I think there would be very few, if any, pathologists in Australia who would go to court and say this means the leg was gripped by hand.
Now, a much more serious question has arisen about where the tissue samples of the bruises really came from. In the first trial, Dr James said no sample was taken from the right leg, and his source was the body chart prepared by Dr Manock during the autopsy.
I'm guided, of course, by the records of Dr Manock here.
Yes, of course.
I have a chart of his in relation to this case, which indicates that one tissue sample was taken from the bruise on the top of the head, and one from the bottom cluster of the 3 bruises on the left calf above the ankle, and the third section was from the bruise on the inside of the left ankle.
So from 2 areas?
Yes, the leg and the head.
And Dr James continues.
Apparently no tissue samples were taken of the bruises on the back of the neck and the right shin.
Not right. One of the photographs not disclosed to the defence proves the body chart, and therefore Dr. James's evidence was wrong. It shows tissue was taken from the right leg.
Have you seen that photograph before? No.
So why was it not on the body chart Dr. James referred to? And more particularly, why is there no photographic proof that tissue was taken from that crucial thumb mark on the left leg?
Have you seen a photograph that shows a section taken from the inside of the calf on the left leg? No.
The body chart Dr. James used was never made public. But in the second trial, Dr. Manock produced this one, which revealed samples were taken from both legs. How can there be two body charts telling different stories? And even then, the official version still doesn't quite match the photograph.
Everything should match. I mean, an autopsy is an integral part of the criminal investigation.
And if they don't match?
Well, you certainly couldn't rely on them.
In this case, once the hard light of review get put on this case, you have to accept that the record is weak, and part of that record is insufficient samples have been taken of a wide enough range of tissues.
And if all this seems improbable, ponder for a moment on the way our Director of Public Prosecutions disregarded the substitution of the gun in the Nima case until Today Tonight exposed it. In the Keogh case, there's so much which doesn't satisfy a proper chain of evidence, such as dates which don't add up and the testing of items for which no record exists.
Well, there's no comment that a jar of blood was taken, and then there is no comment that the stomach contents was taken.
While John Nader is at pains to point out his comments are based solely on matters of principle and not aimed at individuals, he says attorneys general, by definition, have a duty beyond politics to see that justice is done.
That duty is an absolute duty. He cannot back off that. An Attorney General who does not approach that job with complete integrity is derelict in his duty.
Well, after the break, why were Dr. Manock's apparent errors allowed to go unchallenged? The experts asked, given so many concerns about Dr. Manock's abilities, where was the medical board that should have called him to account?
It should be all above board on the table. I mean, after all, we're not talking about a Spanish Inquisition or a tin pot dictatorship.
Welcome back. Well, given all of the evidence, who can we now expect to act? In any case of a major miscarriage of justice, who can the South Australian public rely on to see that mistakes are set right? Henry Keogh has now spent the best part of a decade behind bars. And while so far the Attorney-General has refused to be moved, it is certainly the Medical Board's role and responsibility to review Dr. Manock's performance in his case. But as Graham Archer continues, it is not something they're eager to do.
Do you think the board's the best forum for it?
Well, I'm not an expert on it. I mean, I think my answer would be the obvious one, that of course it's not. But they've exhausted all the other avenues.
Professor Ross Calusi is a current member and former president of the Medical Board. In discussions on another topic, we raised with him the board's confusion over its own rules. This is what their website has to say about investigating complaints.
It says that, according to the Act, a complainant has two choices. They can go to the registrar, or the complainant himself can investigate and present the matter to the board, according to the Act. But the Act doesn't say that at all. Section 54 says, D says, complaints alleging unprofessional conduct on the part of a medical practitioner can be laid before the board, D, by a person who is aggrieved. It doesn't then go and say that they have to investigate their own complaint. I mean, that would be...
What has this got to do with what you said we were going to talk about?
Well, it's about the process.
Surely the meaning of the Act should be fundamental to any discussion. As for the Medical Board's claimed lack of investigative resources, well, that goes straight back to the Attorney-General again. For a law and order government, there appears to be a lack of interest in ensuring there's some order to the way the law is administered, and that is a problem for us all.
It should be all above board on the table. I mean, after all, we're not talking about a Spanish Inquisition or a tin pot dictatorship. We're talking now about a healthy democracy.
It seems to me that there should be no hesitation about ordering an investigation. If it transpires that the body of evidence, the weight of the evidence is against these forensic pathologists who have been critical of Dr. Manock, so be it. All it can do is clear the air and exonerate the Attorney-General.
Plenty of questions which still need answers. Graham Archer with that report.